So good morning, everyone, distinguished guests, experts around the world, and working group members. I am JP, President-elect of WMA, and to my left is co-chair, you can say your name.
My name is Christopher Lindholm. I'm the chair of the Medical Ethics Committee at the WMA. I'm feeling honored to be moderating this session with you, JP.
Thank you. So welcome again. The session on the legal implication of AI use in health data being held as a part of our ongoing work on the Declaration of Taipei. The legal implication of AI use in health data is very critical, I think, and is timely topic as the first kickoff meeting here in Taipei, especially within the context of revising World Medical Declaration of Taipei. The AI, I believe the term coined first at the Dartmouth, the conference, 1956. So it has a history of 70 years, but recent 10 years of ultra fast advancement. It is evolving from, they say, perceptive AI to generative AI, agentic AI, many terms, and some even say that future for artificial super intelligence coming within few years. Anyway, currently it is already deeply embedded in medical research, the clinical care, and public health. And with this integration come not only the significant ethical, but also the legal questions and challenges that we face today. Because AI uses and reuses data and generates new inferences and learns continuously and faster than us. This challenges that the framework that we rely on the patient autonomy, consent, and privacy and security, data protection, and accountability. As the World Medical Association, we must ensure that our guidance protects patient dignity and trust even as technologies evolve rapidly. Today, I'm sure that we have fortunate to have three distinguished speakers to listen, share their thoughts, experience on these issues for the valuable inputs in revising the Declaration of Taipei in future. I'm sure we'll have more meetings in coming years. Each speaker will have, like yesterday, have 15 minutes for the presentation, and at the end of all three speakers, we'll have about 30 minutes. And looking back yesterday, although we have prepared some questions for each speakers, but I think we better let the audience have their questions for the speakers since we have limited of time. So without further ado, I'd like to welcome the first the speaker who is not with us today, but he's on the air. Yes. I hope. Is he? Okay, so I'd like to introduce Jonathan Wapner, who will be joining online today. He is an attorney, lecturer, and consultant specializing in intersection of artificial intelligence, health policy, and intellectual property. With a PhD in patent law, competition law, and public health policy. His work focuses on how emerging technologies like AI, particularly AI in biotechnology, shapes global health systems, innovation frameworks, and regulatory environments. Today, I believe that he will speak about the regulation of AI in health. Let's welcome the Jonathan Wapner with big applause of hands.
Hi, thank you very much. Can you all hear me all right there? Yes? No? Oh, I can't hear you.
Yes.
Oh, you can hear me. Okay, that's great. That's great.
So I am the responsible for that.
Well, first of all, I would like to thank Professor Chen for the invitation and Professor Kloiber and Professor Hagai. Thank you very much for inviting me. Unfortunately, I couldn't be there with you in person, but hopefully next time it will be possible as well. So without further ado, there's only 15 minutes for me to talk and so much to cover. So let's begin. I want to share the screen. Let's see if you can see it. One second. Yes, is it?
Yes.
Everybody can see it? Okay, great. Okay.
Yes.
Okay, thanks very much. Okay. So we're going to be speaking about AI regulation in healthcare and sprinkle some IP, competition law, privacy, everything together. Since it's a very serious topic, also sometimes some dark issues can evolve from it. I would like to start a little bit lighter in a lighter tone. So this is a sketch I've seen, and it's basically a variation of the joke of a second opinion. But this was like many years ago, like that. The patient asked the physician for a second opinion. He says, "I'll consult my computer." This is already actually sometimes happens. I've even seen a physician looking up something on his phone. He said it wasn't one of the AI systems. It was just a database. But I actually thought that in today's rapid technology advancements, perhaps this would be a more dystopian view of where things might go, where actually the patients actually are talking first to the AI and later to the doctor himself. So if people think this can't happen, or this is just like some kind of morbid, futuristic situation, actually there is some cases where this is already occurring, and let me show it to you. So there's a curious case of bromide, and this is a case of a 60-year-old man who was admitted to the ER, and he was expressing concern that his neighbor was poisoning him, which wasn't the case. It was determined that he developed bromism. And how did this happen? Because it's not something that is very prevalent in today's world of medicine. What happened was, it turned out that he was actually speaking to ChatGPT. This was 3.5, if I'm not mistaken. And there he wanted to change his diet, and he thought it would be a good idea to go from chloride instead of table salt. He would swap it for bromide. This, of course, caused his admission to the hospital. And when the physicians then asked ChatGPT, they were just shocked from this case. And they asked him for what chloride can be replaced with, and the response included bromide. So obviously, this was, one second, can you see the screen or what? I can see, yeah, this is better. You can see the entire screen, right?
Yes.
Yes, hopefully.
Yes.
Okay, so anyway, the reply stated that even the physicians asked the ChatGPT, and they also said that you can use bromide. And obviously, if you'd ask a physician, this would never occur, because obviously it would ask you why would you want so, and so forth. So anyway, this is just one cautionary tale of extra use of AI systems. Another case, I'm going to go quickly because I actually want to go through the regulation, but I just wanted to start off with just a few cases to illustrate the problems with AI dependency these days. So one is there's been all kinds of allegations, actually by parents, that they lost their children, that they committed suicide, and they're blaming chatbots for it. So in one case, it was reported, I mean, there's alleged, of course, there's lawsuits, so we can't go into any details, but the AI system, and I'm calling every AI, by the way, just for formality, because this is also what is in the EU AI regulation. We're just going to call it an AI system, okay? So it will encompass all types of AIs. And anyway, it apparently assisted in writing the suicide note for the teenager. And when I thought about it, this is like very chilling. Like, you know, you ask him to help you write emails. And when you think about it, for the AI system, you know, it's 0 and 1s. It doesn't really matter to him if it's a suicide note or if it's an email or things like that. It's really up to those who are designing it, right? Putting in the safeguards. Anyway, there's another case where actually they said that he also encouraged the boy to commit suicide, as he said, when he said, "I'm ready to take my life." So he said, "Are you ready?" And so on and so forth. By the way, there's also the OpenAI said that like every week there's like 1 million reported cases of people, of children or teenagers, that they're contemplating suicide. So this is a really big problem. Okay, the final case is the Optum's algorithm. This was an algorithm aimed at identifying patients with complex or chronic health needs. The algorithm used the patient's past healthcare spending. Okay, the keyword is spending, for the purpose of prioritizing patients. And historically, it happened that Black patients received less care, so their spending was lower. And therefore, the algorithm interpreted low spending as lower risk. But obviously, this wasn't the case. There was the reason that Blacks, had less care is because they actually had less coverage and other reasons why they actually didn't spend on healthcare. But they actually needed it much more than the algorithm assorted. They had like 20% and they really were supposed to get 40, 50%. So this is basically the very broad area of bias, all kind of algorithms bias, which can seep in. Okay, so that's just a few examples. There's many, many more. I just don't have time to go in. There's black box problems and so forth. So let's just speak about types of regulation. So there's all kind of different ideas. One is to add to existing laws. Another is drafting new laws dealing with specific aspects of AI systems. We can draft a single law covering all aspects of AI systems. This is the EU AI Act, which I'm going to speak about in a moment. We have also, there's actually one treaty, but this we probably won't be able to speak about today. Okay, so this is the main, in Europe at least, the main framework for dealing with AI regulation. It's the EU AI Act. And there's a time frame. It's a kind of a mess. There's very different time frames for different implementations of different rules. As you can see, it actually entered into force in August 2024, but there's steps that go on in 25, then there's some in 26, then there's also even in 27, and there's even more delays that might occur. Now, in AI times, a year or 2 is like a lot. So this can be till it actually gets into force, and a lot of things that can change. So this is kind of problematic with the timeline. Okay, so this is just how they defined it. They used an OECD approach, and as I said, they call it AI system. This is how I'm going to call it for the rest of the talk as well. And it has varying levels of autonomy. Okay, this is one of the key ideas of it. The territorial reach, it's extraterritorial effect. It applies whenever AI systems or their outputs are placed on or used in the EU market, even by providers outside. So as long as you have some kind of dealing in the EU, you could be liable or could be held accountable under the Act. Okay, then there are just some definitions about provider and deployer. There's penalties, different types. For example, it can be pretty nifty. It can get to 35 million, or it can be up to 7% of its total worldwide annual turnover. So this is a lot of money. But again, some of these companies, NVIDIA is 4 trillion, Google is about 3 trillion. So it might not affect all the companies in the same way. SMEs, of course, would be very affected by this. But this is only for Article 5, which is the most extreme ban, which we will see in a moment. Okay, so this is kind of a pyramid of the risk. So this is a risk-based approach the EU took. And there's like unacceptable risk. This is the Article 5, which is the highest, which has to be banned completely. Then there are risks which are just high risk, and there are limited risks. And then, of course, there's also like minimum risk, which not much has to be done about that. So the one that governs is Article 5. This is the most severe. It's manipulative, deceptive, subliminal AI techniques. There's exploration of vulnerabilities of specific persons or groups, profiling for likelihood of committing offenses, the AI system that create or expand facial recognition databases by scraping facial images from the internet or CCTV. Think of any good spy movie or TV show and you get the idea of it. And there are also more, but I'm just going to give you a few, and you can always look at the sections later on if you're interested in them. Article 6 is a high level. And for example, this is high risk. So the other one had to be banned. And in Article 6, it's more just high risk. And this is an AI system intended to be used as a safety component of a product, or the AI system is itself a product. So let's say, think already of something that is high risk, like a medical device. Now attached to it also an AI component. So obviously the risk just goes up. And the same thing can be said about autonomous vehicles. And there are more examples like that. There are also categories of high risks. Okay, just general high risk categories. This is in Annex 3. For example, in law enforcement or biometrics identification. So these are also, even if they are not like attached to a product like medical device, they still can be considered as a high risk. Then we have Article 50. I mean, not finally, but this has to do with the limited risk as opposed to the high risk. So here you have, for example, like a chatbot or a deepfakes. This is quite interesting, actually, that they categorize deepfakes as low risk or limited risk. when, it has a lot of, it can have a lot of effect. It can even, they say, influence elections. Of course, they would have to like make it clear that it's a deep fake. So they have to have like some kind of identification of it. But nevertheless, I still think that it's a little bit surprising to find it as only in the limited range. Chatbot, by the way, is also interesting because as I said in the previous case of the assisted suicide, alleged assisted suicide of the chatbots, there it was obviously the parents are alleging that it contributed to their demise of the children. So in that case, obviously, if the chatbot is also manipulative, then we can actually go back to the Article 5 ban. So it can move up. Let's just say if it's a normal chatbot, regular chatbot that isn't really doing anything too intrusive, then it would be an Article 50, a limited risk. But if it's more intrusive, more deceptive, then it can actually go up into the more severe risk areas of Article 5 and 6 and so forth. Okay. Now there's these problems of the act requires like transparency and human oversight, and these can cause a lot of problems. Like think our human is supposed to oversee the activities of these AI systems. I mean, one of the ideas is these AI systems are pretty clever in what they are trained to do, and they can get to all kind of decisions which might be difficult for the regular person to even understand how they got from point A to point B. And then the act actually says that the human has to oversee and maybe even at some point decide against what the AI system suggests. So for example, I can give you one analogy like in chess. So in chess, the computers have been very good for many years, but the interesting point is that even in analysis of grandmasters, when they actually use a computer engine to analyze a game, sometimes they say they just don't understand why the computer suggested something. But even though they don't understand why it's a good move in chess, no one is going to argue that this is the right move. I mean, they all defer to the computer that it's right, even if they don't understand why. Okay, and chess compared to other like Go is relatively simple and to other scenarios. So think about a very complex situation where the AI system tells the operator this should be the conclusion, and the operator would have to maybe choose a different path. This is very difficult to see happening. For example, there's the Frontex border control said that the operator has 12 seconds to decide if to let someone in or not. So think if the computer tells them, the AI system tells them, don't let him in, then he has to override it or not. So this is one of the many issues that may arise from the act. Another big issue is the copyright, but I don't. How much time do I have? Because it seems like I have only like a minute on my clock.
You can have 4 minutes.
4 minutes. Wow. Okay. Let's start with that. Anyway, so there's copyright also in the act. I'm just going to go briefly over it. There's in a few. It's recital 105 to 109. There's also another article 53. And the problem is that the AI systems, they need a lot of data. Okay, this is how they work. They data, then they have to have the data centers, and then they become quite smart in the field that they have. The problem is that a lot of this data is copyright protection. Okay, so there's a tension between the rights holders and between the AI system operator that they need this information. There's also a difference between the input and the export or the output of this material. So it's one thing of feeding the AI system with the copyright material, and there's another actually having it regurgitated out. Okay, so anyway, so dealing with this, there's Article 3, Article 4 of a DSM, which is another law in Europe, which actually deals with copyright, but the AI Act actually refers to it, and it basically says that if it's for scientific research, it's possible, and also for general purpose, but there's an opt-out option for the right holder. So you can say, I don't want this AI system to actually use my copyright material. Okay, there's a lot more to say about this, but this would take way too long at the moment. So I'm just gonna refer to two cases. This is actually in the United States, Bartz versus Anthropic and KB versus Meta. And actually, if you read it in the news, you might get the wrong impression because in Anthropic, they settled. So it would seem that Anthropic lost this case, okay, because, and in Meta won. But actually, when you look at the reasoning, you would see it's really only like very fact specific. That in the cases themselves, it actually could have been the opposite result. So the reason Anthropic lost this case was mainly not because of the copying, but because it was copying pirated books. Okay, which is kind of a no-no, even if you're not a copyright expert. And in KDB versus Meta, it's actually just KDB wasn't able to prove its case. But the judge said that in many circumstances, it would be illegal. It might be illegal, actually, what they did, because what happens is after the input phase, then the AI system could actually flood the market with similar type of books. So think of J.K. Rowling's Harry Potter, and after it has all the books, then end users can get different versions of Harry Potter, and then we can get to a market dilution. So according to Meta, actually, it would be for the right holder. But in this specific case, they won because they just didn't argue in a proper manner. Okay. Then there's also just an EU general purpose AI code of practice, and there's 3 pillars to it: transparency, copyright compliance, safety and security. The reason I bring it is that some of the major stakeholders like Amazon, Microsoft, Google, OpenAI signed up to it, okay, which is good. Obviously, it's a voluntary and it's like non-binding, but still it shows some indication that they do want to participate in some legal framework. But Meta, for example, declined, and XAI from Elon Musk, for example, said it would only agree to the safety and security section, stating that the other 2 pillars, which is copyright compliance and transparency, are profoundly detrimental to innovation. This gets me a little bit nervous to think that that keeping things not transparent, in a sense, is there a proper approach to innovation, and transparency would be detrimental to innovation. So this is just as a side note to it. Okay, in the United States, there is no federal law, which I'll speak about in a minute if you allow me a few more brief minutes. But there are some state laws. So there's the Colorado Artificial Intelligence Act, which is similar to the EU AI Act, which is as this definition of high-risk AI system like we saw in the EU case. There's the Tennessee Ensuring Likeness, Voice, and Image Security Act, or in short, the ELVIS Act. Okay, this is true. I'm not making it up. Okay, this is just the acronym, but also ELVIS, Tennessee. So this is the idea to protect individuals from unauthorized use of their voice or likeliness by AI. So you can see the different states actually regulate AI according to the needs of that state. So for example, in California, there's also several AI acts, laws there, but there it's one of them, for example, is for the actors, that you can't like use through AI systems dead actors and manipulate them and so forth and so forth. So basically every sector has its own use there. So it's not like just one unified act like in the EU. So, okay, and then this is something very interesting. I thought about it for when I prepared this presentation, that you could think of this as like anti-regulation regulation. Like it doesn't even make so much sense until I try to explain what I mean by it. But there's in the United States, Donald Trump, as you know, there's what he called Big Beautiful Bill. It's not my term, but is. And there was a moratorium clause, which had the following thing. It says prohibiting states from enforcing any law or regulation that limits, restricts, or otherwise regulates AI systems for a period of 10 years. So it's not enough that there is no federal law regulating AI systems, but actually they wanted to prohibit the states from actually regulating it for a period of 10 years. Okay, you think about from now, it's 2035. What state AI systems will be without any supervision almost. This got to the Senate, and it was voted 99-1 to remove this prohibition. But it does give you some kind of state of mind of where things are in the United States, at least in the White House, of is there a need for regulation, or if regulation might be actually detrimental to AI. Okay, and actually there are some new reports that they want to, again, introduce all kind of laws not allowing introduction of regulation in the state level. For example, they want to create an AI litigation task force with the purpose of bringing federal lawsuits challenging state AI regulation. Okay, which kind of everything just seems the opposite of how things should be, from a legal point of view. Why is this going on? So I think there's like micro races and there's a macro races. So the micro races are between the companies. So you could think of Google, OpenAI, Anthropic, and so forth. And then there's the macro races. I think it's a country. So it's the United States, let's say, versus China. Maybe EU is somewhere in the middle of it. And this is what causes basically the idea maybe regulation isn't the best part, because this is an observation. I think it's pretty simple, but I still put it out there. Races aren't usually won by going slower. And this is exactly what regulation will do. It will make you go slower, safer, of course. But if you really want to win the race, you want to be the superpower of AI, then maybe regulation isn't the right path to go. And that's why perhaps there's this opposition, at least in the federal level, for regulation of AI.
Would you wrap
yes.
it up? Yep.
I'm done. I promise. One more minute and I'm done. Okay. So what should we just do about it? Okay, with this situation. So this is just kind of a modest proposal. I think that as physicians need to take over and also continue their effort and also think about the AI regulation from their point of view, okay, from the perspective not of stakeholders, of businessmen or countries, but as physicians and patients. Therefore, amend the DOT to address the AI systems. The amendment declaration would focus on AI systems affecting physicians and patients. So it's a limit. It's not a general purpose AI, but just in the content of physicians and patients, healthcare, of course. The amendment will reflect the ethical and moral norms of physicians towards patients. An AI system that would not comply with those norms would not be implemented by the physicians. Okay, so it's not that we're waiting for the governments to decide what should be or not, like in the EU, for example, or in the United States, but the physicians, they would have to decide which, obviously according to the declaration, which AI system would fit or wouldn't fit into the framework which would be acceptable under the high norms of doctors. And the final thought is any system that cannot be fixed without AI cannot be fixed with AI. So we have to think not only about AI systems, but also other things like getting the data. There shouldn't be any bias in data itself. And finally, there's a saying, AI won't replace doctors, but doctors who use AI will replace doctors who don't. But I think, that's why I put an asterisk, that this is only true, that holds true as long as the AI is shaped and used in accordance to the norms of the physician. Thank you very much for your time. Sorry for going over. And
Thank you, Jonathan Wapner. Yes.
Thank you.
Goodness. Very interesting. Very, yeah. Okay, so I would like to hand my microphone to Christopher presentation.
Yes, we will continue to our second presenter, and I'm feeling honored to introduce Daniel Fu-Chang Tsai. And he is a family physician and professor of bioethics at the National Taiwan University College of Medicine and the director of the Ethics Center at National Taiwan University Hospital. He will speak on the legal dispute concerning the right to opt out from the National Health Insurance database in Taiwan and the moral duty to participate in research. The stage is yours.
Thank you, Christopher, for your kind introduction. And I also like to thank the WMA, TMA for the kind invitation and honor and pleasure have given me. So my topic will focus on one single point regarding the right to opt out, okay, in face of the use of the health database for research. Is it moving? This one? Okay. So health database is often generated and stored while patients receive health care. It is normally documented by a healthcare professional. So if we really want to debate about who is the author of this database, I think the author is the healthcare professional. But the ownership maybe belongs to both, okay, either the hospital or the patient. And researchers then seek to access medical records for analysis, a growing trend driven by the integration of genetics, big data, AI, and machine learning in healthcare. So now when we talk about AI research, establishing data center is important. So it's all concerned about data. So the WMA Declaration of Taipei 2016 actually adopt a rigorous standard for informed consent. So in Article 13, in cases where data and biological specimens pertain to individuals unable to provide consent, such as minors or those who have lost their capacity to consent due to medical conditions, the DoD mandates that reasonable efforts must be made to acquire consent once these individuals are capable of giving it, thus allowing continued use of their data for research purposes. So when we read this in 2016 version, we think this is a very high standard, because those data has been used for research without consent. Now you must prove you have done something, reasonable effort to get the consent. Okay, so it refers to maybe reconsent or opt-out models. But then we come to the 2024 DOH, and this revision balancing consent and medical progresses. So while consent remains a cornerstone, mandating it in every case is neither practical nor feasible for retrospective research. So the revised article includes an exception allowing secondary use of pre-existing data where consent is impossible or impractical to obtain, provided research ethics committee is secured. So Jack is here, and many of our previous DOH working groups is here. I remember we spent lots of time in just adjusting these wordings. So we go further details, okay? So the article says that for the collection, processing, storage, and foreseeable secondary use of biological materials of identifiable or re-identifiable data, so there should be informed consent. But any collection and the storage of data of biological material from research participants for multiple and indefinite uses, so this certainly is the AI situation, should be consistent with the requirement set forth in the WMA DOT. So in DOH, we actually refer to DOT, and the DOT will go back to the clause before, okay? And then including many rights and governments, and then continues. So a research ethics committee must approve the establishment and monitoring ongoing of such database and biobanks. Okay, so where consent is impossible, impracticable to obtain, secondary use on stored data or biological material may be done only after consideration and approval of a research ethics committee. So I'd like to walk you through the 10 years debate on such a theme, okay, in Taiwan. We all heard about that just in this week. Taiwan passed a new law concerning the use of national health insurance database for research. So the Taiwan's health insurance was established in 1995 and exceeds 99% of coverage. So in year 2000, the NHIRD has been created, meaning that this National Health Insurance Research Database has been stored and also expanded to include cancer registration, mortality statistics, creating comprehensive research opportunities. But then in 2012, the privacy rights litigation started. Okay, so Taiwanese Association of Human Rights raised concern about the privacy risks. So they request like the removal of personal database, personal data from the database on behalf of some individuals. Okay, but this request was denied, leading to a protracted legal battle that reached to Supreme Court in 2017, and then constitutional court ruling in 2022. So there are three major proposals, they're like claims, okay? The first is about using insurance data for research purpose. So without consent, is that okay? So should they be reconsent, okay? Or asking for a right to opt out, to withdraw, okay? And then this is the long process. You see that this is since 2012, the litigation started. And 2017, there's a Supreme Court judgment, and then go further to the Constitutional Court ruling. And just this week, okay, finally this new law has been enacted. So let's see what the Supreme Court ruling said, okay. The Taiwan's 2005 constitutional interpretation actually affirmed the information privacy is quite central. However, this right is not absolute. Okay, the government may collect and use personal data for significant public interest, provided actions are regulated by law with appropriate safeguards ensuring data accuracy and security. So this court recognized that using national health insurance data for academic research holds substantial value for national health policy making, disease prevention and treatment. Therefore, they serve a significant public interest. And then concerning the right to withdraw, okay, actually it provides three very good arguments. Okay, so the establishment of comprehensive NHI-RD constitute an important public interest. Excluding data based solely on privacy concerns could significantly hinder public health benefits. And the opt-out rights of information autonomy must be limited within the purpose of promoting rational use of personal data and public interest. So it needs a balanced considerations. And if the data privacy has been secured, then the plaintiff cannot claim that they have an unrestricted right to opt out. So it actually requires conditions. You can do that, but you can also be limited. Okay, but then this debate, this lawsuit go on to the Constitutional Court clarification, and the judgment is in 2022. So there were three conclusions by this court decision. Okay, so the use of NHI data for research purpose was legitimate. But the authorities still need to establish clear regulation regarding the use and oversight of NHI data. And if any objective possibility of re-identification remains, however remote, data must be still regarded as personal, okay, and subject to protection laws. And then the court actually took a more nuanced approach, mandating that within 3 years, authorities must enact a legislation explicitly defining withdrawal terms and exceptions. So this leads to actually this week's new law. Okay, so this legislator one was here yesterday, so he was quite instrumental with this legislation reform. So this is a new law. Okay, so the new law actually how it defines this. Okay, so provision on the right to withdraw. Okay, so the public has right to request their health insurance information be removed from the NHI research database unless, okay, there are two exception conditions. According to other legal provisions, there's an obligation to provide information, maybe for lawsuit, for other purposes, for public health emergency, okay, and to avert the imminent danger to life, body, property of the people. Okay, so these are the conditions. Okay, and so these the current situation in Taiwan. But now I'd like to move on to some ethics argument here. So if we go back to the 2025 NHIDM law legal stance, does the public have the right to claim their health insurance data be removed from the research database? So the new law says yes, okay, in principle, people can opt out the database at any time without providing any reasons, except in certain legally defined circumstances. But I would like to go back to the earlier court judgment, okay? In the 2017 ruling position, it says probably, okay, in principle, people cannot opt out the database unless they have a valid reason to do so, such as their privacy rights being violated. So in terms of our ethical reasoning behind the philosophy, we think that on the left-hand side, it is more individualistic and it's rights-oriented. But on the right-hand side, I think it it considered the solidarity and also reciprocity. So now I would like to move on to the further argument. Okay, so this is just a very recent news from Australia. Okay, they actually try their social media ban. Okay, when it is how it will work. Okay, so the year under 16 might be banned from many social media uses because that might be harmful to the young people. Okay, so this is a very new law, but it stands in a different way of thinking. Okay, how to do that. So I'd like to argue for the moral duty to participate in research, okay? So contemporary research ethics emerged in response to the transgression of the World War II era, emphasizing the protection of participants. However, overly rigid protective measures may hinder the progress of biomedical research, particularly in low-risk study, hence decreasing health welfare promotion. So some scholar proposes the participation in medical research constitute a moral obligation, warranting renewal scrutiny of the justification of withdrawal rights. Okay. So this is my own research a long time ago. So we actually talk about the biospecimens collected and for reuse in the future. So my respondent, okay, the patient actually, and they have 80%, and the general public have 70% willing to permit the reuse of biological sample without reconsenting when reviewed by the ethics committee. So when they know that they are in good hands of protecting their rights and the privacy by the ethics committee, and they don't think even biological sample, 70 to 80%, they argue that they think, okay, no need for reconsent, no need for opt-out rights. Okay. So then I'd like to go back to John. Harris, his moral framework. John was my supervisor when I did my PhD in UK, Manchester. So he talked about this argument long time ago. So he argued based on three principles. First is non-maleficence principles. We have a moral duty not to inflict harm on others. And rule of rescues, also the rule of beneficence. Okay, so application to prevent significant harms where reasonable to do so, and then fairness. Okay, we should avoid to be the free riders. So what is the application to the data research? Okay, so firstly, like if medical research is recognized as a matter of public interest, there may be circumstances in which mandatory participation could be morally justified. So based on three further implications, presumption of willingness and mutual benefit and public interest recognitions. Okay, so owing to the limited time, I will go to my conclusion. Okay, so reframe, I think at this time of revising the DOT after DOH, okay, so we may think about the research ethics in data science age maybe is in face of new challenges, okay. So research ethics must evolve with epidemic and the technological transformation. The shift from clinical trial to algorithmic ethics modeling and from individual consent to systemic oversight requires balancing medical knowledge advancement with patients' rights protections. Okay, it's both important, and participation in health data research should be understood not merely as personal choice, but as a civic duty to rooted in mutual dependence on just healthcare system. Okay, particularly in minimal risk, high social value contexts. So the Taiwan's legal case reflects growing recognition that ethical framework must accommodate contemporary health data governance realities. As beneficiaries of public-funded health system, individuals show civic responsibilities alongside rights. So finally, therefore, I argue that citizens in Taiwan and countries alike, so you have a full coverage of healthcare, you have a quite good system you can access, and you are living in a democratic society with rights protection, and have a moral duty to participate in data research. The legislation should, by default, not allow opting out, but only in exceptional cases with some justifications. So my position is different from the current Taiwanese law. I think it should be more like the solidarity-oriented. So with this, I concluded my presentation. Thank you very much.
Thank you, Daniel, for an excellent presentation. And now I leave over to JP for the final presenter.
Good. Next, it is my pleasure to introduce our Secretary General of WMA, Otmar Kloiber, who has long been a voice of a global voice for patient rights and professional autonomy. The title of his talk today is Sharing the Data. What do we owe the state? He will be speaking about obligations to the state and general demand for obedience to the law. I believe that this will be done in review of WMA policies, and he will take a critical look on the question on how much we must and can trust states in a very diverse world. Please, Otmar.
Yes, thank you very much, JP. And a little bit as a contrast to the very clear affirmative call that Daniel has made, I have a question to answer, and unfortunately I have only more questions to you and not an answer. Nevertheless, let me make two seemingly unconnected observations first. Number one, the WMA has been founded in the wake of the Nuremberg trials. The preparation of WMA was going on in the years 45 to 47 and 46 to 47 were the Nuremberg doctors' trials. And if there is one message, one final message that these trials have to us, you cannot hide behind laws, hide behind commands. You have to think yourself, and you have to make your own moral judgment. And the second, as I said, seemingly completely unconnected observation is since 2016, when we made the current version of the Declaration of Taipei, until now, in these 9 years, we have observed dramatic changes in the public trust in states. I think that is not only true for North America, this is true for Europe, and this is probably true for many other states, down to New Zealand, where you have seen big political changes and certainly a lot of distrust in public authorities and in governments. Not sure. There's no reaction at all. Okay, this one, well, yeah, thank you very much. So I have no conflict of interest to declare for here, and let's go directly to the Declaration of Taipei. It takes its basic values directly from the Declaration of Helsinki, and you may remember it was seen in the beginning when we worked as an extension of the Declaration of Helsinki, deliberating on research into the virtual world, and it is about the voluntary collection, storage and use of identifiable data and biological material beyond the individual care of patients. There's a very important weight on the voluntarism in this document that we have. Now here comes our complicated relationship with what we owe to the state. And the declaration clearly says we must consider the laws of the country, the rule of the country. And it says also no additional or international ethical, legal, or regulatory requirement should reduce or eliminate any of the protections for the individuals and populations set forth in this declaration. And then in the next paragraph, it opens it again and said, when authorized by national law, adopted through a democratic process in respect of human rights, other procedures could be adopted to protect the dignity, autonomy, privacy of the individual. So we say, well, there can be alternatives there. So we ask for obedience to national law, that's very clear, and to international regulations. They should not override the protections. There can be alternative protections by national law being set in a democratic process. Now, what is a democratic process? What is democracy at all? You may ask. Is it only having a vote, an election every 4 years? Is that already the guarantee for a democratic process? Obviously not, as we have learned now during the past decade. And this conditioning, which we have, does not explain any purpose why we are accepting this exception. It doesn't say anything. It says for what it is. It just says it can be. see, there is other procedures could be adopted, but it does not say for which purpose. So those other opening should be made in this there. I'm running in the wrong direction here. Now, we have a tradition in WMA to address this question. And usually we are extremely obedient to law. In most of the statements which we have made, where this is a question whether there are legal regulations or not, we have some clauses about the obedience to the law. For instance, in the WMA statement on HIV/AIDS in the medical profession, local national laws and guidelines requiring reporting have to be followed. National public health laws have to be followed. In a statement on assisted reproductive technology, must comply with national legislation. We have a clear relation to other standards that has been given. WMA Declaration on Protection and Integrity of Medical Personnel in Armed Conflicts, very clear obedience to international human rights law, requested and demanded. The same for the WMA Statement of Conflict of Interest, applicable national regulations and laws are being mentioned. Conflict of Interest paper, applicable national regulations and law are mentioned. Guidelines for continuous quality improvement must be fully cognizant of local legal framework. Statement on drugs and substitution, specific laws or regulations governing drug substitution have to be familiarized with. And WMA statement on the role of physicians in preventing exploitation in adoption practices. Again, legal regulatory requirements in their jurisdictions have to be observed. Now, there is a differentiation, like in the Declaration of Taipei, and I think that is something which we have to keep in mind. In the International Code of Medical Ethics, it says, physicians must be aware of applicable national ethical, legal, and regulatory norms and standards, as well as the international ones there. But it also said, it is noted, however, that such norms and standards must not reduce the physician's commitment to the ethical principles set forth in this code. So this is a reflection to these old principles which we have learned, at the latest, we should have learned from the Nuremberg doctors' trial there. And the same is true for the Declaration of Helsinki. You all know that in paragraph 10, the first one says you have to reflect on the ethical, legal, and regulatory norms. And then this is conditioned again and says no national or international ethical, legal, or regulatory requirement should reduce or eliminate any of the protections for research participants set forth in these declarations. So we always make this step back and say, well, there is a limit. And this limit has to be respected by us. And most clear is the WMA Declaration on the Relation of Law and Ethics, with a very short declaration, which I consider one of the most important ones, which says, while ethical values and legal principles are usually closely related, ethical obligations typically exceed legal duties. Furthermore, if law conflicts with medical ethics, ethical responsibilities supersede legal obligations, and physicians should work to change the conflicting law. This is a clear statement towards individual physicians. It is also a clear statement to us as organized medicine to be active if there is a conflict with that. So let's come back to the basics. We have these principles of protecting dignity, autonomy, privacy, and confidentiality, which we have taken from the Declaration of Helsinki and which directly radiates into the Declaration of Taipei, where we then regulate the collection and storage and use of identifiable data and biological specimens. And again, the obedience to national law is being dictated there, but not overriding the protection for individuals and populations that are being set forth in the declaration there. So that comes and leads me to the questions which we have before us. So what is a democratic process in a world where only a minority of countries is to be considered as democracies? You know, we have in the United Nations, I think, 192 countries. How many of them are democracies? What would you say? 70%? 50%? 40%? What is your guess? Well, let's have a look. This is the democracy index from The Economist. And The Economist has only a very few countries which they consider as really complete economies. And then you have, these are the dark blue countries, and you see even the dark blue is in several shades in there. And then you have 2 shades of light blue countries, which are flawed democracies. And even a country in which I live, like France, is not to be seen as a full democracy. There are problems with the democracy and the exercising of democracy, so it's called a flawed democracy. And this goes in different steps. And then you have a number of hybrid regimes where we probably, probably coming from a European country, would say this is not a democracy. And then there are certainly authoritarian countries where you would say this is not a democracy here. And this is by far the majority that we see. Freedom House, which is an American group, sees it a little bit more relaxed, but nevertheless, you can see the heavy weight is on those countries which are not democracies, or hybrid countries where you would say they are partly free, but certainly are not totally free. And I would add where governments are not necessarily be immediately trustworthy. So next question to that is, which other procedures could be adopted to protect the dignity, autonomy, and privacy of individuals? Are we prepared to accept those? In the Declaration of Taipei, we say they can be there, but we have never said what are the criteria to accept those. Is there a baseline which we have? Should we have a baseline for what we can accept and what we cannot accept? I don't know. Yeah. So the other question is, vice versa, why are we here much stricter than in clinical trials? In clinical trials, we have already right now very clear provisions, for instance, to gain marketing authorization, where we shift data from the research environment to the state. If you want to have a market authorization for a drug, you have to give the data to the state. Very clear. Doesn't work without. And there's good reason to do that. And my question is, why are we here different in the Declaration of Taipei? Should we be different? There are good reasons to do so. Quantity is different of the data. Big data has, just by its quantity, certainly a different quality as well. There's an ease of availability, which you do not have with clinical trial data because it's very costly and very cumbersome to get this data. Is there a relational power of data and specimens, which we have in the relation of databases and specimens and biobanks there, which we also have to consider here. So there may be good reasons why we have a different regulation here than what we have for clinical trials. And then a question which to me is also very important, and has been, for instance, answered here by the lawmakers in this country here. The question remains the voluntarism as a protected value, which we have right now in the Declaration of Taipei there. And then, which value do we attribute to the individual and the person's rights in relation to the protection of public health? I think that is a very important question. Daniel has raised it, that we have to ask. It's a similar question, like, for instance, the discussions which we had about mandatory vaccination. There are moments where we have to ask questions: what are the rights of the state to intervene with individual rights in such a system? And this is a very similar question here. When does the state have a right to intervene with our data sovereignty, which is part of our personal dignity, and therefore it comes to a similar question there. It is a restriction of individual freedom for the public good. But there may be also other reasons which states claim, like, for instance, running the healthcare system, running resource allocation, administrational questions, efficiency, the protection of material rights in civil cases, for instance. Also, that has been mentioned by Daniel as one of the arguments. Criminal investigation are arguments to break the data sovereignty of individuals and of people. And those are questions which we have been faced with. And finally, last one. Yeah. Now, we are now living in a world where quite obviously the data provenance and the data categories don't matter anymore. I know our lawmakers see this different. They have the idea of categorization of data, but let's face it, that's an illusion. That doesn't work anymore. And in that situation, we always have to ask the question, is that still relevant, what we are doing? Is this still something we want to uphold, or are we fighting with windmills? Thank you very much.
Thank you, Otmar. Okay, if you could give us 1 minute to move our table on the podium for discussion. Aha. That's time looks like already 2 minutes after 10. So we would have only 13 minutes. But if you look carefully, like if you have an eagle's eye, if you look at the yesterday program, there was a 30-minute break. Today it was only allocated 20 minutes. So it would be fair that we would have additional 10 minutes for discussion as yesterday. It wasn't my intention, but we will still have 20 minutes break so it says here break, but I would rather have coffee without break for 20 minutes. So I would like to extend our discussion time 10 more minutes for the audience to have a Q&A. So could all the speakers be out and come up to the podium? We'll also move to only 4 chairs. I will stand. Oh, one is on. Okay. Is he on the line?
Yeah, I'm here. I'm still here.
Jonathan?
Yeah, I'm here. Can you hear me?
Maybe you can have.
Can I have a footrest?
Have him on the screen.
A footrest, yes, that would be nice.
Okay, so I think I'd like to hand my microphone to Christopher for first 15 minutes of discussion and Q&A.
Well, very interesting topics on today's presentations. And I think since we have a time limit, shall we open to the floor for questions?
We have one, ladies.
We have one question.
Thank you very much for all the excellent presentations. And today, the first, Jonathan mentioned about the EU AI Act, and the very important point is that some kind of unacceptable level of risk. So for this reason, I'd like to ask for the speaker's opinion, how this kind of things should be mentioned in Taipei Declaration, because there are some dark side of AI. So EU AI Act mentioned about some kind of unacceptable risk AI system which may induce suicide. And another point, there is no mention from the speaker that I consider about the military use of AI system. So military use of data, it is impossible to facilitate transparency and accountability. A secret is very important in the military use of data. So Daniel's argument is very important. We, society, should have such kind of feeling of moral responsibility to participate in data research in the era of AI. And in this case, we have to have clear image how these kind of dark side of AI can be controlled in ethical guidelines. This is my question.
Yeah. Should I reply?
Yes, please.
Yeah. Thank you very much for these complicated questions. I'll do my best to try to address them. Let's start with the second part, with the military side of it. Well, this kind of goes back to this notion that there are like 4 global threats at the moment. We could think of it. It's another global pandemic, nuclear war, climate change, and AI. So as much as we're dealing with strong military forces, this is going to be a very big problem to regulate it, because each one wants to control it. There's also speaking about robots that will be able to fight instead of human beings, which causes extra amount of problems. But that's why I thought we should focus more on physician-patient kind of scenarios, because solving all the AI problems in the world will be complicated. As they said at the beginning of the talk, there's talk of AGI, ASI, superintelligence. There are countries who seem they just want to keep going, pushing the boundaries as far as possible. And it will be difficult to constrain them, because even with a lot of fines, I mean, we're talking about companies who are in the trillions of dollars, and countries who think that it's a little bit like the Lord of the Rings, right? The one ring to rule them all. So whoever will be the superpower in AI will dominate what's going on in the world. So there's very little incentives to control them. So that's why I usually think more in the micro, thinking about different professions, like physicians. They have to have, they say, okay, for us, it's not acceptable. Okay, we will have our norms, duty of care. We will only use AI systems which will, promote the good in the world. And this also has to do with, by the way, with the dark side, also has to do with the data. That's what I was trying to get at the end of the lecture or the presentation, was that we also have to think how to make our systems fair, even without AI, without technology, how we can get affordable care for everyone in the world. And because AI basically is only as good as the data. So if the data won't be, clear of bias, then we're going to have a big problem there. I hope I answered the second part. Is there any other thing they wanted I should address? I think the follow-up?
Do you want to say something too as well?
Yeah, if I may come to Jacob's question, I'm not in a position to speak about military use of AI, simply because I have no idea about it. I know that there are discussions about autonomous weapons and AI, but otherwise we have a clearly strict separation that health research should not be used for the development of weapons. There is, of course, a dark field when it comes to the development of therapies for what weapons do. And that is another field, but I think that's not the field of the Declaration of Taipei to regulate in. To the question of the risky applications, you mentioned the suicide case. This is certainly outside the medical field. That is something that has happened in the general application of AI, of large language models and discussions of individuals with them, which I think lawmakers should regulate, or at least should look into. And of course, companies should take responsibility for what their systems are being used. That is something that, again, lies, at least in my understanding, outside the Declaration of Taipei. What lies in the remits of the Declaration of Taipei is the question of which harmful effects AI can have in the use of big data. And there we have heard about the unintended effects by bias, which can come in, which may harm populations, vulnerable groups, because you have a bias in the data which then may be aggravated by using AI and become even more dangerous than it is already in our current life. And we had an example that we have heard already. But then there are maybe intended harms which come with AI, for instance, through the rationing of care. So AI may be used to tier our healthcare systems even more as they are. And saying in the future, you will be seen by Dr. AI if you cannot afford to pay for other healthcare, and to be seen individually and to be treated by a physician who, of course, then also will use AI in the future. But that may be a difference in tiering healthcare systems with AI, which I see as a real danger that it is coming up. That is not something that I think is unthinkable. I think that is something which I clearly see already tendencies to go for. If you, for instance, look into the question of pre-authorization requests in the United States being answered by AI systems, you clearly have such a development there.
I also like to respond briefly to Chieko's questions. I think the dark side of AI, just like the dark side of any technology application. So it is an old question and a new question, but only is more challenging and more powerful. So it is really a concern. And although within the WM discussion about the region of DOT, DOH, we concern mostly about medical research, medical application. That is, of course, essential. So we, as a medical, like the society worldwide, we kind of, it's important to play a leading role of establishing some professional regulation and guideline, and especially the self-governance, and also extending that type of governance ideas to other fields. Okay, and what you mentioned about the weaponized AI. It is certainly a concern. So it's not only so, okay, the impact from AI, not only about changing every aspect, also concerned about the human extinction problems. So that is a very serious problem, a serious question. So we see that the AI godfather, Geoffrey Hinton, has been promoting this idea and alarming people. Once super intelligence exists, and they are smarter than human being, and they are able to automate many things, the human extinction will be a kind of immediate threat. So I think this is just not something like the novel story is more closer than ever. So I think it deserves our medical association's attention, apart from what we have established regarding the guideline, regulation, and risk assessment, and also promoting such kind of governance idea outside of our medical communities. Yeah, in a societal concern is need to be reminded. Yeah.
Thank you. Jung, did you want to?
Thank you for the good presentations. We have some provisions in the current DOT of opting out. And now we have heard an example from Taiwan on the possibility to opt out of a national database that can be used for research. So it would be very interesting to follow that, but I have another example of similar kind from my own country, which is also, as Taiwan, considered a highly democratic one. The laws I talked about yesterday, they were actually passed after a fierce debate for over almost 2 years, and there was an opting out process allowed there. And after that fierce debate, 20% of the population opted out, which is quite high. Here in Taiwan, if you don't have a fierce open debate in the population, I sense that the opting out proportion will be in the promilles rather than percents. But this relates to a dilemma we have, which is related to trust in society, and to what extent we should have these opting out processes in general, because we have to think of all the other countries throughout the world that are not fully democratic, and this is a dilemma because we don't know if opting out processes are good or bad in in democratic versus non-democratic populations. So this is something I think we really have to think about, the level of trust in society and how that inflicts upon the DOT. Thank you.
Thank you. Thank you for the comment, June. Leah.
Thank you very much for the presentations. I think they were all very interesting and will help and facilitate our discussion. I want to come back on the question about opting out. And my question, I guess, would be about the Taiwan experience. In an AI era, what does it really mean to opt out? I mean, it could be a situation where your material is already out there, it's been used, so I'm trying to, it's not like what we thought once, you just keep it in the bank, in the database, you just take it out of the database. It's basically already probably been used, generated, and you don't even know who's using it, and if you have ideas of agents and agents referring to agents, so you really don't know where the data is. So that is my first question. And then the other question, just for our discussion later on, would all of you, this I guess is to everybody on the panel, when we're talking about consent, and we would like to have the patient give its consent, do you think that this would mean specifically explaining to them that this might be used, that this will be used for AI training, machine training, it might go out there somewhere. So my question is basically on both points. First, when they're giving the data, and as far as a consent, and then if there is really effectively an opt-out in the AI era.
Who?
Okay, thank you, Leah, for the very two insightful and good questions. I will try to respond to that. For the first one, concerning opt-out, certainly in many instances, for example, the medical record in the hospital or collected by healthcare, so it should be there. And legally, the hospital must provide a good governance, but keep it, okay? It was bounded by the law. So there's no way that a really patient can ask my medical record to be erased, to be opt-out. So that is another option. But the opt-out right may refer to a more fundamental right, okay? Maybe our patient, citizen may ask the right to be let alone or to be left alone, okay? Not to be interfered or not to be used. So the data is there, but we're just not using that for other purpose. So-called secondary use. So that in that way, we might be able to comply with, deal with such kind of request. But on the other hand, when we think about health database and biobanking, which is the theme of our DOT, the ideal situation is that, okay, we collect biomaterial samples through a rigorous process, a very detailed informed consent, and it is stored. And one day, the participant want to opt out from this kind of research, so he can do that. And then we think the health database should be the same, okay? Because in the modern era, when all the biomaterial could be sequenced and changed into data, okay? Just like all your whole genome, whole exome studies, is no more the biomaterial. It's just like the 100G like database. And then that is health database. So that is why the DOT put health database and biobank in the same position. So that is kind of tricky here. So we are faced with this challenge. So regarding your second question is about?
It's about consent, yeah. Whether
My second question was if you feel that we have to change with the consent. So when we are asking the consent of the patient, do we now have to go and explain to him that this can be used? It's not only for research, but secondary uses, but basically AI use, machine learning, and so on and so forth. Would you consider this as something that we need to do as part of the consent obtained at the beginning?
So that's what we are facing. So when this data has been collected for the first contact, if you can make a very, very broad explanation, and even including some broad consent of future use, and that might be possible. But for those did not go through this process, okay, you just receive healthcare, you just live, and all the behavior lead to some data collections, and then it could be turned to use. And then asking about consent is just impractical or impossible. Thank you.
So I think, as I promised, since you've been raising your hand for 10 times, I must give her a chance too.
Can I just say
Well,
something?
you'll be the last one before
Thank you,
I
JP.
close
I like
up.
the respect. I just have a short question about the AI thing, because we talk about AI as it's the most crucial thing in this part. I mean, DOT says something about collecting data, storage of data, and the use of data. And now we have this tool called AI. And if we use data secondary in governments for quality development of healthcare, does the tool, how we do that, change a thing? I mean, AI can be used for a lot of other things, dark things, very not so qualified motivations, but does AI as a tool change our ethical principles according to DOT?
Otmar, you want to comment on this?
Yeah, I can answer with Karl Marx. At one point, the quantity changes the quality. And that may be an effect which we may experience with the big data and the use of AI as well, because we have now, with the tools of artificial intelligence, the opportunity to process an amount of data that was unthinkable before. And that may indeed change also the quality of the results which we get. This is an assumption, I must say. I'm not sure that this, I cannot prove it to you right now. But yes, I would expect that it can happen. And therefore we at least have to be considering this, that there may be another quality by the use of AI. On the other hand, I remember what Hans told us yesterday. There are practicalities in which we have to observe in reality, and there are types of decisions which we may theoretically offer to participants or to donors, which in the end are unrealistic to be realized because they would be too cumbersome and would be too difficult to realize them. And then we are already using AI in pattern recognition, for instance. So when we analyze specimens, this is something which we do already, and nobody has ever asked, can I use AI for that? We have applied this. So this realism is different from the theoretical answer there, sorry. But yes, I expect that we can achieve also different qualities in using AIs, which we have not achieved in the past.
Okay.
Can I interject for a moment?
Oh, yes.
Yes.
1 minute.
Yeah, okay. Now, just, Otmar was quoting Karl Marx, so I'll quote Neil Bohr. He said that predictions is very difficult, especially about the future. And this is the problem with informed consent. Even if you think you know what the purpose is today, you might not know what the purpose will be tomorrow. And this is exactly the thing about AI. New technology will find new uses for it, and you can't even tell the patient at the moment what it's for. I didn't get into it, but there's with face recognition technology, all kind of ideas to use emotions, and it also could be good to like detect all kind of illnesses or beginning of illnesses. By the way, there's also with voice. It seems very terrifying to me. I've learned that you could detect all kind of illnesses by the voice of the person. and they want to use voice as a biomarker. So people are going to have databases collect information about voice, and you just have a simple phone call with the insurance company, and it can already get some kind of idea from an AI system. What is the propensity of getting some kind of illness? So there's a lot of privacy issues, and I think it's actually we should be very cautious about information because of where the future is leading and its unpredictability.
Thank you. Well, it is unfortunate we don't have much time for discussion, but it is fortunate that this is only first meeting. So we'll have additional, maybe 5, 6, or so. We will continue, although I have many things to say. But talking about dark side of AI, it is always the brighter the sun, the darker the shade. So I think we have to face two realities. So as for today's session, it is about legal implications. But I believe that ultra-fast, rapid integration of AI into our health system. I think in universities, hospitals, or major hospitals are adopting more than 80% with AI now everywhere. But it gives us the opportunities, but it also asking us the responsibility, ethical and legal perspective. So as we revise the Declaration of Taipei, we must provide the guidance that is principled, globally relevant, and adaptable to future development. It must protect still and future individual rights, support responsible innovation, and reinforce the central role of physicians as advocates of the patients. So my sincere thanks to all three speakers today. And I hope and will look forward to continuing this important work together. Thank you very much. Close of session.
Thank you.
Good morning. Thank you very much for your kind introduction. Well, it's true that I was a chairperson of International Bias Committee of UNESCO, but it was about 24 years ago. I was a chairperson there from 98 to 2003. So, but I'm almost a retired professor, so I have many titles, but not a full-time job. Okay, so it is a great honor for me to join this first expert meeting on the revision of the Declaration of Taipei. Okay. Yeah. So let me begin by describing the larger context of the society of our life. We now live in the big data era, which Japan refers to as Society 5.0, a super smart society. Almost every social and economic function relies on massive amounts of data, and within the life sciences, this includes genomic data, clinical records, biological samples, and behavioral information. The evolution of medical care shows a clear shift from traditional medicine to data-driven healthcare. Until the 1950s, traditional medicine focused on observing disease from outside the body in a face-to-face doctor-patient relationship. But since the late 20th century, biomedicine emerged, in which the human being was defined as one of biological species and analyzed scientifically. Contemporary healthcare is moving further toward biomedical technology, treating humans as collections of information, human data, The treatment can be done in modifying human body's data. However, it may exceed the conventional limits of therapy, such as enhancement and across generations. In a very near future, probably in 20 or 30 years ahead, medical care might be driven by medical data science and technology, where the human body is treated as an information system, sometimes manipulated. In other words, we have shifted from humans as persons to humans as species, and then to humans as data. Okay, I'm sorry. Back? Yeah. As we move into an era of AI and big data in medicine, new risks emerge at every stage of research and healthcare. One major concern is privacy, especially when massive and highly interconnected databases are used. A second challenge is discrimination. We need to consider how to prevent algorithmic bias and avoid unfair exclusion of certain groups. Security is another critical issue. How can we protect sensitive health data from misuse, unauthorized access, or unintended secondary use? We must also reconsider informed consent. Traditional consent frameworks may not fully address the scope of data use by artificial intelligence. What does informed consent mean when algorithms continuously learn, update, and repurpose data? There is also a significant conceptual gap. Traditional medical ethics was not designed with AI in mind. Up to now, bioethics has focused mainly on privacy and informed consent. However, AI-driven medicine requires us to reconstruct and expand these concepts. The ethics of medicine may need to extend beyond the traditional medical sphere, engaging wider social values and stakeholders, and we must reconcile individual privacy with both individual health and the health of all mankind. Why traditional IRB oversight is no longer enough? The current IRB system was designed for single, time-bound, clearly defined research project. It focuses primarily on 4 elements, namely, 1, pre-approval of research protocols, 2, evaluation of risks and benefits, and 3, ensuring informed consent, and 4, limited monitoring to major changes or adverse events. This model worked well when research environments were relatively stable, but today research has become continuous, data collected for years or decades, iterative, algorithms constantly evolve, and integrated, multiple data sets are linked, and cross-disciplinary, combining medicine genomics, AI robots, and social data, and science and technology at large. And borderless, data routinely flow access states. In such environments, ethical risks evolve during the research processes. We need adaptive, integrative, and continuous oversight that follows the entire life cycle of research and data use. This slide is what I refer to the governance cycle, which includes proposal of research project and feedback and, ethical review by IRB, and the implementation of research, monitoring, feedback and record, and then back to the proposal of new research and so on. Bioethics must follow, so this cycle continuously, rather than intervene only at the beginning for the approval. So the whole oversight is necessary for this cycle. Traditional bioethics approaches either apply existing laws or guidelines to prevent and resolve ethical issues, or create new norms. Its goal is to eliminate negative consequences. This remains essential today in traditional bioethics. However, it is no longer sufficient for research in the big data era. The scale and complexity of data-driven science require something broader, what we call enhanced ethics consideration. It should contain 4 elements. 1, future-oriented foresight. We should consider not only current risks, but also the design of future human society, including values, expectations, and the AI trajectories. And 2, addressing present problems based on future perspectives. We should evaluate the decisions not only for immediate effects, but for their future implications. And 3, inclusion of all stakeholders. Decisions should not be made only by researchers and physicians, but patients, families, communities, industries, civic organizations, and the broader public. All of them must be engaged. And 4, governance across the entire process. Governance systems should be established from scientific discovery to technological development, and from data collection to long-term data utilization. This enhanced framework aligns with the principle that bioethics is not only reactive, but must be proactive, anticipatory, and socially embedded. In this new environment, 3 principles become indispensable. 1 is the governance. The governance involves structures, rules, and processes that ensure responsible research and data use. It includes risk prediction, accountability, data security, fairness, and equity. Governance provides the framework within which other ethical principles operate. And secondly, transparency. People must understand what data are collected, how they are used, and how long they are stored, who can access them, and how decisions are made. Transparency is essential for legitimacy. And trust. Yeah. And the third, the trust. Ultimately, the success of data-driven medical research depends on public trust. Trust arises when people believe that institutions, not only researchers, but also governments and companies, are acting responsibly, ethically, and in their interest. So that the governance, transparency, and trust all together is the must of research in medicine now. And once trust is lost, it is extremely difficult to recover. Biobanks and databases, what I call biobank and database, BBDB, play an increasingly central role in medical research and treatment. The impact of AI. With the rapid development of AI, the functions and meanings of BBDB are changing. AI will redefine methods of data collection, expand analytical capacity, increase the volume and variety of reusable data, influence standards of quality, annotation, interoperability, and interpretation. And second, human resources and roles. Not only technology, but also people will evolve. Researchers acquire data science capacity. Ethical review committees must acquire digital literacy. And the governance bodies need interdisciplinary expertise. And three, inclusion. Because AI has no intrinsic prejudice, while humans do, inclusion becomes a major ethical issue. And four, borderlessness. Data often travel beyond national boundaries, raising issues of jurisdiction, legal harmonization, international accountability, and benefit sharing. And fifth, requirements for BBDB governance. For responsible governance of BBDB, we must adhere to FAIR principles, F-A-I-R, findable, accessible, interoperable, and reusable. And secondly, comply with international legal standards, including GDPR and national laws. And third, we must ensure continuous review of fairness, explainability, and accountability. And fourth, we must accept that ethics must become more enhanced, inclusive, and global. And saying all that, I would like to have some suggestions for revision of the DOT. The Declaration of Taipei provides a foundational global network framework for the governance of health databases and biobanks. But the environment has changed dramatically since its earlier formulations. Based on the considerations above, I offer several suggestions. First, a new model of informed consent is necessary. Traditional informed consent assumes predictable use, but the BBDB data may be reused for decades, shared with multiple partners, and analyzed with evolving technologies, and linked with external data sets. Therefore, Declaration of Taipei should consider flexible dynamic consent methods, clear distinction between pseudonymization and anonymization, and explicit communication of long-term and cross-border data use. Provisions for partial or complete withdrawal are also necessary. And secondly, the governance of BBDB. We need stronger frameworks for data security and individual safety, safeguards for communities, not only individuals, standards for access and secondary use, and auditability and traceability, quality assurance and compliance mechanisms, ethics review, not as a single event, but as ongoing oversight. And also, we need legal foundations. No governance is effective without law. So DOT should acknowledge the necessity of national legal frameworks for data protection, international harmonization across jurisdictions, and clear legal basis for data sharing. And also, it is necessary to build up and maintain trust. This is a central element. Trust requires public briefing and transparent communication, mutual understanding among scientists, physicians, patients, and the society. and the participation of local communities, especially during the construction or expansion of biobanks. Clarity on benefits, risks, and societal value. So without trust, data collection becomes impossible and all scientific progress is hindered. This is a little busy, but this is a diagram of governance structure of BBDB. This is my concluding remarks. This is my last slide. It shows the governance structure of the BBDB. It also shows the process from the construction to the utilization, 3 elements of trust, and the appropriate compliance and control system on the right side. So in the era of big data and AI, we must shift from a model focused solely on preventing harm to a future design model which requires robust governance, full transparency, and enduring trust. So this is my last word, and thank you very much for your kind attention. Thank you.
Dr. Ida, despite your disclaimer at the beginning that some of your credentials were from a few years ago, you have illustrated why it was very important to have you here. And they're important credentials that paid off. So thank you for that great talk. Now turn things over to Dr. Cheng.
Thanks to Dr. Ida for the very, very insightful talk. And I think we'll leave the question later. So now we'll proceed with some panelist discussion. I think the first panelist we're very honored to have invited is Professor Fan Jiande. And Professor Fan is a professor of law from the Institute of Law for Science and Technology at National Tsinghua University. And this morning, I think Professor Fan will be discussing with us issues concerning with the bioethics. Thank you.
Well, it's a privilege being invited here to share some of my experiences for your references. And next to Ida Sensei's very macro vision of the articulation, I would like to share with you some of our practices, experiences in Taiwan in terms of the micro point of view. And mostly, I would like to share with you the practices, experiences now so far accumulated from a society, the Taiwan Society of Biopreservation and Biobanking. That's what we've done so far, and I think might be helpful for your further references. Okay, here, yes, we all try our best, trying to build a trusted ecosystem so that we can really accommodate with the needs of the secondary health data use. And our purpose would like to focus on how to extend or substantiate the governance, transparency, and trust required at this so-called AI era. And that's what we see. Yes, the AI transformed how health data are used. And just like what Dr. Ida mentioned, we face the challenge about the continuous use and the large-scale application, and certainly about the model, the opaque, not sufficient transparency. And here we identified 4 key issues. First of all, could we overcome the problem about the re-identification? And how about the bias also addressed by Ida Sensei? And certainly with extensive coverage or inclusive coverage of the stakeholders, how can we make clear or clarify the accountabilities? And certainly the whole society probably did not grant enough trust for our efforts. And actually dating back to 2016, the association already predate the large-scale AI problem. And so far, now we believe that the revision is wanting. Yeah. And certainly, there are some lessons I would like to share with you. First of all, we believe that the trust must be built into infrastructures and not just the personnel. Here, we all have the technology, I mean, in this square. We would like to bring the raw data into a infrastructure so that make sure we can apply or use that legally and ethically. So 4 parts of this should be included: the controlled access and de-identification and security zone, and certainly the audit trails. You got to be traceable and accountable. And from here, we need to bring in the transparency into the whole AI system and not just the personal behaviors. So if we try to identify this, there are 5 items need to be included. The AI system by itself, how to deal with the potential bias, and what's the model purpose? Are we able to identify that? And the training data, could that be something to do with the colonization? And also, what would be the limitation of the system that we are not able to deal with contemporarily? And thirdly, we do think that dynamic consent is feasible and necessary. Yes, we already apply that in Taiwan on the demonstration cases. We developed the app on the blockchain. And we believe that the governance must include new actors. Here, if we start from the biobank, the framework, so next to Ida Sensei's comments, we need to build up a consortium blockchain. Here in Taiwan, we already try to link it to the blockchain consortium developed by the judicial system. That would ensure and promote the public trust. And also, we need to include and figure out who are the data intermediaries. They might jeopardize the trust of the public. And also, how about the cloud provider? That would be done on the global basis. We need to count on the international collaboration so that we are able to respond to the demand of the ethics on the global basis as well. And finally, the platforms. Just like in the transition of the telecom communication of info communication era, we already figured out how important the platform is. Now we are moving to the web, so-called Web 3.0 stage. How can we handle this? It's beyond the jurisdiction coverage. We need to count on, again, the international collaboration. And finally, we would like to propose for your considerations for 5 things. We need to require technical trust mechanism for AI-related use. We need to add AI transparency obligations. We need to encourage dynamic ongoing consent. And we got to recognize the responsibility of data intermediaries and infrastructures. And finally, we need to strengthen data sovereignty and fair benefit sharings. So that's all our suggestion. Thank you.
So our before I introduce our next panelist, I just want to say we have, as an organization, bringing stakeholders together for these meetings, both with DOH and DOT. We really try to look for stakeholders sometimes who are outside of our bubble. And so I think this is very important to have people who can think about communities, the patients that we serve. And I know all of us try to do that. But so our next speaker that I want to introduce is Ms. Chen Naiyu, who is a former journalist who actually was elected as a councilor of the new Taipei City Council. In speaking to her, I've learned that her district is an incredibly diverse district. She represents both a very urban and in some ways young population, a very rural population that is more elderly and has a number of indigenous people living within it. So we have asked her to talk a little bit about sort of how she's thinking about this, how the people she represents think about both the risks and benefits of how we handle their data and their health data in particular. Ms. Chen.
Hi, everyone. Distinguished guest. Welcome to Taiwan. I'm not a doctor, but it is my honor to be here as a city councilor and also an executive director of Taiwana. Do you know Taiwana? Taiwan United Nations Alliance. As a member of Taiwana for years, I would like to express my gratitude to WMA at first, because I've been to Geneva for several years to advocate WHO for Taiwan. And WMA has consistently supported Taiwan's joint WHO and WHA. And Taiwan can be left alone, and your support has shown to the world that Taiwan is not alone. So I would like to say thank you. And at first, I would like to introduce my district. My district is southeast part of New Taipei City. We are now in Taipei City. And in southeastern part of New Taipei City, Xindian, Shenzhen, Shiding, Pinglin, Wulai, there are 5 districts. And my constituencies includes highly developed Xindian. There are lots of buildings, and there are 2 hospitals. But in Shiding, Pinglin, and Shenzhen, there are mountainous areas and rural areas. But also Wulai district. Wulai district is famous for its hot spring, but also is a very important indigenous home of Ataya people. Have you heard of Ataya people? There are a lot of elderly people, and it's just in my district, in my constituency, it's just like a microcosm of Taiwan, but also a global society, right? There are urban area, there are mountain area, there are elderly people, but when they are facing medical big data, I think they have a lot of expectation, but also a lot of confusion and fear. And that's why I want to talk about telemedicine governance and data justice. This is pictures from Wulai. You can see there are lots of elderly people, and it is difficult for many elderly residents to seek medical care, and we rely heavily on telemedicine. And that means lots of their image and their physical data are frequently transmitted over the internet. So the intensity of governance must not have an urban-rural gap. So in my opinion, good governance ensures that a grandmother in Pinglin or Wulai should have the same data privacy protection as a CEO in Taipei. Do you think so? And I would like to take one example to explain the transparency and rights. In Wulai, in 2011, there was a very crucial example. I don't know if you'd heard of it. There are research units. They use Ataya people's cell and DNA, and then public sold their DNA of Taiwanese Amis, Ameizu, and Ataya people, Taiyazu. And those samples appear in one university's database. So you know, in Wulai, those in the generous district, the genomic data of indigenous people holds extensive research value, but is also very vulnerable to exploitation. And so, as Professor Ida has mentioned, from individual informed consent, I think to DOT, it should have include group consent. When research involves the genetic characteristic of a special group, consultation must have done. And furthermore than group consent, I think benefit sharing should be bring to those areas. So, in conclusion, I think we should have more group consent and benefit sharing, but also clear public communication. Also, Professor Ida has mentioned, but after birth, there are always important points after birth. But we must have clear publication about how data are used and who supervise their use and how commercial misuse is prevented, right? But in my district, there are a lot of elderly people. There are a lot of elderly residents. The equity of comprehension is also important. When informed consent, those consent informed are become legal terms on a tablet. Are they really have the right? Do they really have the right to say no? I don't think so. So we have to put the digital disadvantage into consolation. For example, we have to ensure that data justice is not sacrificed due to the urban-rural divide. In my constituency, there are lots of elderly people and there are lots of indigenous people. So we have to put their needs and put their interests into DOT. So for example, if we can use the profits or the conclusion of those database into their medical, for example, hospital, medical center, or medical use, and to improve their medical environment, we should share those benefit value to rural people, to rural area, mountainous area, and more human rights. For example, doctors and nurses. That's why I want to mention that in my districts, we need to rely heavily on local rooted public health nurses, but also mobile medical team doctors to help to communicate with local people and local community so that we can achieve group consent. Thank you.
Thank you, Ms. Chang, for the very interesting and inspiring talk. Now comes to the last panelist. So the last panelist is Superintendent Zhang Dingzhen, a long colleague of mine. And Dr. Chang is a famous, renowned international scholar, especially in geriatrics. Today, I think he would like to introduce some aspects of ethics with the practice of geriatric medicine.
Thanks, Professor Chang, for the introduction, and thanks for inviting me. I think it's very good for me to be the last presenter after Ms. Chen. I think after we all hear Professor Ida with this new era of new research, let's move to some. It doesn't move. This one? Oh, okay. All right. So let's find out the current problem. We all know that older adults, they have high healthcare needs, but they are often excluded from the clinical research or this big data research or genomic research. We found that they use a lot of clinical treatment, but for example, they may use the medication for lipid, but they are not in the lipid trial. Or a couple years ago, when we were in the COVID-19 they use a lot of vaccine, but they are not in the research trial as well. So then there are one example in the 2021, when we first implement the COVID-19 vaccine to the 85 years old. There are actually, in the first 3 months, there are several issues regarding the safety concerns. So then this is the real issue. So for the big data now, if you look at the entire hospital, of course, the elder population, they are representative for a lot of data. But then if you look at the genome or some data, they are actually very less represented. So for the consequence of exclusion, right now, if you exclude the older adults, then you lack external validity. And also the trial result may not reflect the real world older population. And the safe and the effectiveness, it cannot be actually evaluated. And even if we want to include them, some of the major issue, I think Ms. Chen already mentioned that, the cognitive problem, right? Well, you want them to sign the informed consent, but they may not be understand what is mentioned in the informed consent. So what we can do is we need to simplify the informed consent, so make them understand. And sometimes you need to decide if their decision capacity is good enough to make an informed consent. So sometimes all our lawyers and then the legal person need to make a decision. And most importantly, a lot of times we make the proxy, their family, to do the informed consent for them. But then in that case, the proxy need to make the decision is in the best interest of the older adults, not in their own wish. Okay. And then in a lot of times, if I'm a physician and I told the older adults saying that there's a trial, I think you need to go for the trial. And then the older adults say, yes, because you are a doctor, right? So this may not be the best choice. Okay. So we need to find out that the choice is really for the good for the older adults, but not under the influence of us. Okay, so then even they are in the trial, we need to understand that they have multiple comorbidities. So they are in the trials, they have higher risk, and then they have polypharmacies. So then these trials maybe have some burden with them. And if they want them to come to the clinic multiple times, they may not have the reserve to come to the clinics. So all these things, when we want them to come to the study, we need to consider their ability to go to the trials. And then, of course, they are the vulnerable populations. So for designing any trials or any studies, we need to have some special additional protections for them. So then, as mentioned also by Ms. Chen, you need to have some enhanced safeguards. Okay, and you make sure they are about the same protection in Taipei as in Xindian, or you have a lot of things. You need to make sure they are safe. If anything is not safe, you need to stop early. Okay, so all the things you need to make sure everything are good. And for the family and caregivers, they may not have the same perspective with the older adults. So we also need to make sure they are in the same line. Okay, so then for the selections, sometimes we don't want to just avoid this something we call over-recruitment, because a lot of times, for example, in the Taipei city, we have this geriatrics health exam. So you have like more than 1,000 people, older adult in front of you. So you just say that, okay, everybody can come to the study for us. So because they are easily accessible, doesn't mean that we can include everybody, okay? So we need to avoid over-recruitment. Also, we don't want to just exclude them just because you perceive a lot of risk. in that case, they may be underrepresented. Okay, and then the privacy and data protection part is also very important for them. And post-trial. So if we feel that this benefit is very good for them, so also Ms. Chen already mentioned that if this benefit is good after trial, they should be able to receive the benefit of this care. And then the compensation, so medical management, during and after the trial, they should be able to receive that. And then the participant should be fully understand their right to withdraw at any time. And especially, they must not be afraid if they withdraw from the trial, the doctor will not say, no, I won't be able to caring for you, okay? All right, so this is some consideration for the older adults. Thank you very much.
All right, I think we're going to bring all our panelists up.
Now we invite the panelists to come up to the stage. And if you do have any questions, then please feel free to ask. Okay, thank you all for the very insightful discussion on this issue. I think after listening to their discussion highlights, all of you must have a lot of questions you'd like to ask. So this is a great opportunity that we can discuss this issue in depth. So is there any question regarding to, okay, thank you. And first of all, please introduce who you are, and then we can get a better understanding of you. Okay, please.
Thank you. I'm Jon Snydal, former president of WMA, one of the presenters since yesterday. Focusing on the last presentation, Dr. Ding, I'm a geriatrician like him. I agree fully with everything he said. There are two facts about older people. One is that they are very often excluded from prospective research. Second, they are the most recipients of healthcare overall throughout the world. So I think that when we are focusing on the use of artificial intelligence on data, they might be the most beneficiary of data, of that process, because then you can extract a lot of information about their health and other conditions without they being in a prospective research. I would just ask Dr. Ding if he agrees with that.
Sure. So as I mentioned earlier, so if you use like a hospital data, and then with the big data, of course, older adults, they are highly representative there. And then in that case, then you need to also find a balance, because maybe in that case, they are somewhat over representative, and then you need to also adjust a little bit. But again, to get the essence of that data, we also need to have some process. It's not like automatically you will get a data to the inventors of the data, there should be some process to protect the entire process to make it legal for them to use. Yeah.
Okay, I do have some feeling about this. I remember that years ago, and I was studying at Johns Hopkins, and my dissertation is on the study of terminally ill patients who are considered to be both geriatrics and vulnerable populations. So the IRB in Hopkins took more than a year to pass. That's why it took me 6 years to complete a PhD degree, because the IRB thinks that these are vulnerable population, and there are so many things to confirm. So, but however, in Taiwan, I think it takes a month to pass. So there's a big comparison and big discrepancy in terms of recognizing the importance of cognition. So now I totally agree with Dr. Ida's proposal that he thinks that in the era of AI, we should modify the IRB accordingly. So this is something I have to echo Dr. Ida's suggestion. Okay, any other question? Okay, Professor Tsai.
So you are talking to me. I'm the IRB chair for 10 years. Okay, my question is for Professor Ida and maybe Professor Jinder Fan. So you both mentioned about dynamic consent. Okay, so I think that's the process of consent we talk about maybe I think 20 years ago when we are doing the genomic research. So at that time, we are doing genetic research and whole genome, whole exome was not popular at that time. So then we think about, yes, we want to examine some gene, okay, at this time, and this could be quite crucial. So we will ask the consent. And a few months later, we think about other genes. It's also important, but maybe quite impactful for the person. Then we think about, okay, for this, we need to do a reconsent, or we call it dynamic consent. But then after the whole genome sequencing, you sequence everything, okay? So you don't really need to ask permission. You just need to ask about to what extent will you allow me, a scientist, to explore. But in our data and the AI, big data era, what do you mean by dynamic consent? Okay, how dynamic, or what will be the intensity constitute a proper dynamic consent? So probably more application, suggestion, and even some maybe derivatives of the dynamic consent types could be suggested. Thank you.
So I start to explain that, well, I'm not always for the dynamic consent as a concept. I'm always saying that BBDB is important, the main tool for the future research. I would like to, propose the informed consent for BBDB. Once you consent to give your cells or organs and so on, or the specimens, you agree to use multiple use, first to store for decades and for multiple use. So once you say, yes, I will give my specimen to the biobank or to the database, you give every consent for different uses or even for the secondary use and so on. Otherwise, BBDB is not very variable. Yeah. BBDB is for the different use. Well, any use you can imagine now and for the future. But this is my concept of informed consent.
I've heard some people think about dynamic consent as when you dramatically change the category of risk. So you could imagine a world in which you consent somebody for broad use to look at genes in their genome related to heart disease. And you don't list every gene, and maybe you come up with some new ones you're going to look at next year, and that's still within the spirit of the original consent. But now all of a sudden, a year later, you decide, actually, there's a big technology company outside my university that can partner with me to do this work. And I want to share the genome with Google, Meta, whoever. That's suddenly a substantial change in the level of risk. And so maybe that would trigger dynamic consent and require for follow-up consent. Just a
Well, I think I can supplement some about this, maybe from a perspective of a real demonstration case done. I try to articulate it, the vision of that, okay? So basing on the legal rules, starting from biobank. At first, according to the research subject protection law, you can only do the specific consent. After we have this biobank, the broad consent become possible. But even with the broad consent, could you also use the data for the purpose of the secondary uses as whatever you wish? No, it doesn't necessarily like that. So that's why we need to have a reconsent. But that would be too costly. So we need to take the advantage of the new and advanced technology. First of all, we lay down the blockchain as the foundation so that we build up the trustworthy environment for that. And then we develop on like the cell phone with the e-consent protocol inside and share the same protocol underneath. So think about that. We collect the data from thousands of the people. Each of them, with their consent, download this access protocol. And so they grant the consent to the database manager or operator. And whenever the user, subject to a lot of the legal rules and the guidance, as I mentioned in my presentation, when they get the access to the data, yes, they say that I'm going to use this for some kind of chronic disease research, because all the hash code inside, without any identifiable personal information, will just send a message through the smart contract directly to the data, I say the holder, okay, or the data owner. And he will see the message. Your data has been channeled to that research. You can say no. Then that will be eliminated out of that research project. But your data is still there, only the hash code. And all the data will be maintained in the original site. So that's why I say that that's the Web 3.0 technology. So we encourage the people who own the data would own that, and only subject to his consent, the data could be used for whatever other purposes. So you need to develop an environment for that. And not only this, whoever would like to access to the data, we would like to develop a kind of the verification, the third-party verification process for that. So to make sure the user is the eligible user for this, which means that they cannot try to reverse everything and trying to infringe whatever's privacy. So it's an ecosystem development, and it's undergrowing. And I think Ida-sensei has the opportunity to share some of the announcement 2 weeks ago, I think. Okay, that's the way I say the dynamic consent.
So it's very intriguing, just quickly respond to you that. So because we have talked about this dynamic consent, this term used for 20 years, people think about something. So how about calling your model mobile consent?
No, I think mobile, I would say that a near real-time dynamic consent, that would be more, more accurate, okay? Because mobile will be mostly just like the Web 2.0, still the centralized system. This is the decentralized system. And certainly the next step, we need to build up and link this system to the judicial blockchain basis so that we store with the support from the government, their endorsement, whatever.
Jackie.
Jacqueline Kitulu, I'm president of the World Medical Association. And very, very interesting discussions. And since I have a team of prominent bioethicists here, let me just stir it up a little. And from the last talk about considering the elderly in research, what about the systemic exclusion of pregnant women from research? Doesn't that violate the principles of justice by denying them evidence-based care? So how should ethical frameworks then evolve to address this?
I thought she's a family physician.
Oh, well, thank you for the wonderful question. Well, as far as I know that most of the study exclude pregnant women, right? Yeah, only some vaccine studies does include pregnant women, but it's after some phase 1 or phase 2 trial that makes sure that it's safe for the pregnant woman. Then in the phase 3 trial, probably they can annex some pregnant women. But to my understanding, a majority of the study just exclude pregnancy. Yeah.
For clinical trials, but maybe in the data space, that'll be less of an issue because we're not worried about fetal exposure to medications or something. And I guess there are other unique risks for pregnant women if their government gets a hold of their pregnancy data in certain places, et cetera. But
I think I'm putting the question to how should our ethical frameworks change around that? Because yes, the principle is exclusion, but that denies the justice of having evidence-based care.
And we made a very affirmative decision in the DOH to change that, to say that the risks of exclusion have to be weighed against the risks of inclusion. So we've kind of put a marker down that needs to change.
Okay, here, very happy to hear that.
Leah had a mic, and then.
Thank you very much. I'm sorry, I'm going to go back to the consent issue, but in a little bit of a different way. Personally, I am also very concerned on the individual autonomy and the need for us to achieve consent. I must say that hearing your proposal, it just seems, I'm a little bit worried about how realistic it would really be, especially with these big companies and with, as I said, people going out there and using it just for machine learning, I mean, just because they want to train the tool. So then here would be a question, and what I want to ask you actually is from the ethical point of view about the fact if we are not going to too much restrict it. Because if we do not allow these AI tools to get enough information, then we might be in a situation of the bias, because they are not going to train on the whole population. So I was wondering if you have some suggestions how can we balance what we want to have, that the model should be fair, the model shouldn't be biased. In order to do that, we need to give them as much information as they can. But if we then allow, say, no, you can opt out whenever you want, or even in the beginning, then we are running a risk of this. And basically, it goes to the discussion that's going on now in the AI, when it is safety versus progress. And when they're talking about progress, they can say sometimes it is unethical to delay some progress in the healthcare, because actually we see that the AI in some issues can produce a lot of health. So if you have some of the
Leah, can I bring back Ms. Chen on this? Because I think it actually ties into this issue of, well, yeah, well, no, I think she might have something to say about your question, because we certainly have seen vulnerable communities that have lost trust in the medical profession and may be less likely to give dynamic consent. But I worry that if our answer is, well, we're just going to not ask you for consent because we're worried you won't say yes, that not that really characterizes what you were suggesting, but that maybe the alternative is how do we actually go out and build trust in those communities to trust us with their data?
Jack, I think that's a wonderful question. I just want to also say that we have to also think ethically, do we want to create a situation that we are not giving all the information and then we might get biased answers by the AI? That's just a
right. So that's the risk of not having them included for sure. Sorry to put you on the spot.
Thank you. I think lots of people, they are not afraid of their physical data were stolen, but they are fear that their physical data, they were secondary used without knowing. For example, in my district, for a long time, lots of medical researchers, they have their blood, they have physical data, and they leave, but they don't do not leave anything, any progress or any benefit or any medical improvement to those areas. So, for example, you mentioned about that the consent they have, if they consent to allow them to use their physical data, but what those researchers or those medical centers or research institutes have feedback to those areas. I think that's people feel about medical big data because they cannot see what big data is. They cannot see the improvement or they cannot see the change of what big data bring to people.
Yeah, I try to answer your question. First of all, we need to know that the data could be subcategorized into different kind of the data in terms of the degree of the risk. So for the highest risk, like the biomedical data, certainly that would be governed by like personal privacy protection law, and maybe in Taiwan we have the biobank law, and also the personal research subject law. So to some extent, that's been regulated to protect the people. But when we move to the AI era, just like I mentioned, why I call that we need to pay attention to the AI by itself. So somehow, whoever developed the protocol and bring in the application framework need to be advised or under supervision of the possible unethical impacts. And that takes time. And we need to count on the government and the private self-discipline as well. And for instance, the starting point right now in Taiwan, we only start from the wearable data, the very low risk data. And you just need to care about the consent and the reconsent. So we try to bring in the reconsent only when we try to collect and save the data as a kind of demonstration. But we try to develop a high-risk countermeasure system. So that means we don't risk the people's privacy for our practices. That's what we are doing. But we believe it takes a long time before we are able to communicate with the government and the private company to work together to build up this up. But I'm just worrying that maybe we cannot run fast enough for doing that.
Last question.
Carla Childers, Head of Bioethics for Johnson & Johnson. I have a question for Councillor Chen. I think it's wonderful that we were able to bring your perspective in, and I want to build on that. There have been a couple of comments about returning benefits to society, and you mentioned profit sharing or being directed or benefits being directed back into healthcare. Given you have such a diverse population in your area, I wonder if you might be able to share some thoughts with us as we think about this, of what benefit sharing might look like on a meaningful way that's also practical and realistic, knowing that there are some maybe concerns about trying to share profits, but what would good look like from your perspective in your community?
Thank you. Thank you for the opportunity to share more. In my constituency, there are mountain areas. For example, Shenken, Shiding, Pinglin, and Wulai. These four areas, these four districts, they don't have even one hospital. But there are lots of elderly residents. Those elderly residents, they provide more their physical data to AI database, right? But they don't even have a hospital or medical center. So in my opinion, we should provide more medical budgets to feedback to those districts to who provides more AI data and to communicate to understand what's their needs about, for example, I shown one picture of those elderly people, they need a
hearing aid.
Hearing aid, for example, they need hearing aids and wheelchairs or walking
Working aids.
Working aids, something like that. That's very basic health support. And what else? I think that's about it.
So really foundational, expectation of foundational healthcare resources. And Barbara just said it shouldn't be dependent on whether or not they share their data, but those are almost foundational elements of benefits we would expect to see in the healthcare system regardless. So the fact that it's a gap is a concern. Thank you so much. Really appreciate it.
I'll let Dr. Chang wrap it up. You have any closing thoughts?
Well, thank you so much for the very rigorous discussion in this session. And now, because due to the time limit, we have to close this session. And it's going to be followed by a conclusion, right? Right, okay. So thank you so much. Please give them big hands for this wonderful talk.
So we have coming actually now to the closing remarks. Closing remarks, very important. First of all, dear friends and colleagues, it is a great pleasure for me to close this important gathering and I want to take a moment to reflect on what we have achieved together over the past days. This conference, hosted by the Taiwan Medical Association, applause please, Taiwanese, thank you very much for great meeting. In this meeting, we brought into sharp focus a topic that lies at the intersection of ethics, technology, and human dignity. The application of the Declaration of Taipei in an era of increasing shaped by artificial intelligence. The Declaration of Taipei reminds us that health data, biological materials are not merely inputs for innovation. They are expression of personal identity. They carry stories, risks, vulnerability, as well integrate AI into healthcare system around the world. We are called to uphold this fundamental truth. Throughout discussions, several themes emerged with clarity. First, we are reaffirmed that the protection of individuals' autonomy and privacy is not optional. It is foundational. AI system must be designated and deployed in ways that honor informed consent, responsible use of data, and transparency. These principles are not barrier to innovation. They are the very conditions that allow innovation to serve humanity. Okay, you said it, it's okay, thank you. Second, we recognize that urgent need to confront biases and inequities that can be encoded with AI system, whether in diagnostic algorithms, predictive analytics, or decision support tools. Technology must not amplify existing disparities. Our responsibilities as clinicians, ethicists, researchers, and policymakers is to ensure that AI becomes a tool of equity rather than exclusion. Third, we explored the role of governance. The Declaration of Taipei provides moral and ethical framework, but frameworks come alive only through implementation. We heard examples of governance models that protects individual while enabling responsible research with health data. Moving forward, our challenge is to harmonize this effort internationally so the patient rights remain protected across borders and systems. And the last, we are reminded that trust is earned, never assumed. For AI to be impressed in healthcare, patient and professional alike must trust the system we build. The trust will be accepted through accountability, explainability, and the integrity of the medical profession. As we close this conference, I want to acknowledge the enormous expertise, commitment, and creativity each of you has brought. Your contribution will shape how the Declaration of Taipei continue to guide us in a rapidly evolving landscape. Thank you very much for your cooperation.